Welcome to the Celebrity Estates Wills of the Rich and Famous podcast. In this podcast, we break down high-profile celebrity estate planning cases for advisors and their clients. Most celebrity estate catastrophes are based on the same issues that everyday people face, just with the volume turned up. Our goal is to identify and extract the individual estate planning issues that lie at the heart of each story. We then discuss what advisors should expect and how to avoid common pitfalls. Hosted by wealthmanagement.com Senior Editor David Lenok.
Every estate tells a story. Some define a legacy, while others highlight lessons learned the hard way. To avoid costly planning pitfalls, trust companies, banks, and wealth management firms rely on the full suite of modern solutions from SS&C Black Diamond Trust Services. Whether optimizing for tax efficiency, managing complex assets, or securing intergenerational wealth, Black Diamond helps you bring clarity and control to the most complicated estates. Learn more at www.sscblackdiamond.com. SS&C Black Diamond, powering the future of trust and estate management. Hello, everyone, and welcome to the latest episode of wealthmanagement.com's Celebrity Estates, Wills of the Rich and Famous. For anyone new to the podcast, in each installment, myself and a guest take on a different celebrity estate and attempt to extract some key lessons that planners can apply to their more traditional clients. The idea being that celebrity estate planning stories, although often ridiculous in their details, generally have at their cores very basic issues that could just as easily apply to non-famous or fabulously wealthy clients. To learn more about estate planning and how you can better serve your clients, visit wealthmanagement.com/trusts-estates. Our monthly journal features tax law updates, wealth planning, retirement planning, and much more, written by thought leaders in the industry. That's wealthmanagement.com/trusts-estates. We're joined today by Michael Napoleone. Michael is a seasoned litigator with a proven track record of success representing businesses, individuals, and fiduciaries in complex high-stakes disputes. He has litigated a wide array of matters, including theft of trade secrets, corporate shareholder disputes, contested wills and trusts, claims of fiduciary misconduct, land use conflicts, and high-value real estate litigation. His extensive courtroom experience spans jury trials, bench trials, appeals, and alternative dispute resolution forums, such as arbitration and mediation. Thanks so much for joining us, Michael.
Thanks for having me, David.
Now, our subject this episode is John Amos. Amos was an American actor whose career spanned over 50 years in TV and film. He was best known for his role as James Evans Sr. on Good Times, the father. Some other prominent roles were as the adult Kunta Kinte in the landmark miniseries Roots, and a lesser but pretty classic role as Cleo McDowell, the owner of a chain of knockoff McDonald's-esque restaurants in Coming to America. Amos sadly died of congestive heart failure in August of 2024 at the age of 84. He left behind two children, Shannon and Casey, and an estimated net worth of $3-ish million. In mid-2025, Shannon filed a lawsuit accusing her brother Casey of elder abuse, fraud, and their father's wrongful death. Shannon claims that Casey manipulated John into signing various legal documents, giving Casey near complete control of the estate, while also ignoring John's medical records, isolating and exploiting their father for financial gain, and ultimately causing his death. The complaint also names John's former caretaker and apparent publicist, Belinda Foster, close associate Eugene Brummett, and his production company, Step and One Half Productions, as defendants. And Shannon is looking to freeze the assets. The allegations regarding the care of John and his finances stem as far back as 2019, when The Hollywood Reporter reported that Casey, and I quote, started to keep his father from family and friends by shuffling around various locations while monitoring his communications, at times even impersonating him in text messages and emails. The complaint itself alleges that on multiple occasions, John was left alone in unsafe and unsanitary conditions. In an affidavit, Leslie Franklin, a longtime friend, said the actor was kept in hotels, surrounded by numerous bags of soiled adult diapers and trash. Shannon was allegedly told by her father's doctors that his medications weren't being properly administered. And in 2023, he was treated for an infection in his feet that was allegedly caused by maggots, one of numerous hospitalizations that year, prompting a call from Adult Protective Services and investigations into potential elder abuse. Shannon's claims that she didn't find out about her father's death until 45 days after the fact via social media, and it's made her think that foul play was involved. Belinda, the apparent publicist, fired back that one of John's final wishes was to delay the announcement of his passing because he's afraid his daughter would, quote, turn his death and internment into a circus. According to Shannon, her father, whose mental capacity was rapidly declining late in his life, was tricked into signing new wills and trusts that benefited Casey at her expense. Neither she nor the other beneficiaries of his will are receiving any money from the estate. And in 2020, Casey Amos filed documents reflecting his sole ownership of Steph and One Half Productions, giving him full control of the money that flows through that company. Michael, why does it seem as if disputes like this one between heirs over parental care and inheritance have become more frequent?
Well, I think you're also seeing a lot more publicity about them nowadays too, because especially with Mr. Amos's estate, it's very sensational. So it's a headline grabbing event. People, he was a pretty beloved actor. I was a fan of his, and when something goes wrong with celebrities, it hogs up all the headlines. But this happens more and more frequently. In part, there's multiple reasons. People are generally living longer, and as you're living longer into your 80s or your 90s, that sometimes increases your years of frailty and dependence on others, and the likelihood that there's going to be disputes over caregiving opportunities, where someone lives, who controls their finances, and things like that. You also get into the areas of more cognitive decline. Alzheimer's and dementia rates have risen, which creates disputes, whether real or imagined, that maybe a parent didn't have the capacity to sign the estate planning documents, that someone is now unhappy, are the ones that are in place. You have more and more blended families, multiple marriages and stepchildren. That creates, complicated and competing claims about, loyalty and care and who gets what. And people are separated by distance. So there's increased isolation. And some folks just don't know what's going on with, typically their parents, if they're living next to or close to a sibling. And maybe there's some distrust there. You don't know what's happening. So you start to imagine things are happening. And then when you finally see the will, you might be surprised at what it says, because it might not be what you're expecting.
So before we get to talking about these sort of conflicts in the litigation themselves, it's a bit of a sticky wicket for advisors here. What, if any, and how much of a role does, someone's advisory team, presuming that they have some amount of assets, really have in sort of trying to suss out potential abuse or try to get ahead of this sort of thing before it happens during life?
Well, 2 points on that. One, I'm a litigator, not the estate planner. So I usually only get involved when someone is unhappy with the estate plan someone put in place, or if there is no estate plan that's been put in place. But what people need to take stock of is make sure you have something, because it's better than nothing. And it doesn't have to be a big estate. Even Mr. Amos's estate, as you mentioned, it's only estimated between $300,000 and $3 million, which is, in the scheme of what we do at Day Pitney, is a very relatively small estate. But you don't need to have a lot of money to have a lot of conflict.
Mm-hmm. And that's a really great point, right? That, when we think of especially celebrity conflict, we think it's over dollars and cents. But I think you would agree that in your line of work, more often than not, it's over something more nebulous and a bit more difficult to specifically nail down.
Oftentimes, there's all these stories, usually they don't start at death. They've been percolating usually for a long time. There's some distrust between the siblings. Even in this case, if you look back at the history, there were allegations that Casey was not properly taking care of his mom. So, these siblings have had disputes over these issues for, going back for many years. So this is just the latest and potentially last iteration of what they're fighting over now with their father's estate.
So how does it change things when the person being fought over is dead? Obviously, in 2023, as we mentioned, Adult Protective Services, looked into John, and presumably at that point he was capable to some degree of, at least they could ask him questions and he could answer them. That what influence someone else had over him may or may not have had over him is sort of up in the air. We can't really speculate as to that. But, what changes when, one, there's a person there for them actually to ask questions to, rather than we're dealing with sort of he said, she said?
Well, there's two types of claims. There's the undue influence claims, which only arise after the person is deceased. Mm-hmm. And it's usually a challenge to the last set of estate documents someone drafted that one person is not happy with. And the challenge you have there is those claims don't become ripe until someone's passed away. And then you're missing out on that person's testimony, right? So the best person to explain what they meant and what they intended and why they did what they did is no longer here. So you're then stuck going to other people to testify about intent, and that you've got to reconstruct events through oftentimes circumstantial and secondhand evidence, which is not as direct and it's a lot more subjective. So you're looking at getting testimony from the drafting attorneys, friends and neighbors, the caregivers, family members, medical providers. Then you look at the documents, not just the estate documents, but were there any communications or side writing that explained the intent, why I decided to change my will at this time, why I decided to not leave you what you thought you were getting. And is there evidence that, one family member was isolating the elderly person from the rest of the family? Were they keeping them away from everyone else? And was there a reason for that? Were they trying to manipulate them into changing documents or changing an estate plan or getting access to their finances while they were alive so they can use them for themselves and not for their relative? Right. So that happens in undue influence claims after they're dead. While someone's alive, you would bring like an exploitation type claim and allege that someone's a vulnerable adult and therefore someone's taking advantage of them through a close relationship, access to funds. And that's a different proceeding because then you have the person available to testify and they may or may not be competent to testify. They may be of totally sound mind, or they may be having some challenges where their testimony is not really reliable. You might have to have a capacity proceeding. Maybe the person has to be declared incapacitated. There's two different ways to approach it. Obviously, after they're dead is when usually the most things arise, right? That's when they're concerned that people are surprised with what happened with the will. If you're seeing evidence of a family member spending money in a different way or giving away assets you wouldn't think they would give away while they were alive, then you're looking more at an exploitation proceeding.
Interesting. So when we're looking at these sort of claims, what are sort of the challenges, I guess, that heirs, and this is on either side, face when there are allegations of financial exploitation or wrongful death in these sort of things?
Well, it's always a question of proof. What can you prove, and how are you going to prove it? A lot of what you get into in these cases is everyone talks about hearsay. People misuse what hearsay means all the time. Hearsay is an out-of-court statement offered in court for the truth of its content, right? So when you want to say this person told me X, are you trying to prove it for the truth, or just that person was having a conversation with you? So a lot of testimony that might come in as to Dad told me he wanted to do these things with his assets. That generally doesn't get to come into evidence. So you've got to look at other documents. You want to bring in the estate planning lawyer. Did the elderly person visit the lawyer on his own? Was it a long-standing lawyer? Was it a new lawyer? For example, did the sibling bring Dad to a new lawyer he didn't know before and have new documents drawn up? These are the kind of red flags you want to look for. Was someone creating joint accounts under the guise that it's easier for me to manage Dad's affairs if all the money's in an account I have access to? But once you commingle accounts, a lot of times that's treated as a gift. So all the money belongs to the survivor at the end. So even if someone wants to claim Dad didn't intend to give you all this money, it was just there for convenience, that's hard to prove. Do you have a document that shows that? Or are you just relying on the fact that that's what you believe would have happened? So a lot of this gets into very complicated evidentiary issues, which come down a lot to he said, she said, and it turns largely on the credibility of your witnesses.
Mm-hmm. I imagine it makes it more difficult because we're dealing with intent and obviously and more sort of nebulous ideas like that there rarely is sort of a smoking gun where it's like, this is the one, Law and Order style, where we found this, that's it. There's not really these types of disputes don't lend themselves to finding the murder weapon, so to speak, that proves.
They generally don't, and if you have that smoking gun, you can generally diffuse the situation very quickly, and you don't spend a lot of time in court.
So, how do fiduciaries and the various fiduciary roles that often during the end of someone's life, they'll sort of distribute out some various of their normal rights to either one or numerous fiduciaries, through either powers of attorney or trustees or what have you. How does that affect these sort of disputes?
Well, it depends on who you've decided to pick. I mean, most people will pick a family member to be their personal representative or the trustee or the person with the power of attorney, which in most instances, when you don't anticipate disputes or problems down the road, that's probably fine. But if you're in a situation where either you have a lot of money you think people are going to fight over, or if you are leaving your assets to people in an unequal way or in a way that they are not going to expect when they see it at the end of the day, then you're better off looking to hire a neutral, either a corporate trustee or CPA or a lawyer, someone who's emotionally and familially detached from the relationship, so you don't have the same sort of accusations that you were the person that was picked and you were manipulating dad or mom into picking you, because through that process, you also got them to change their documents in your favor and to penalize me from what I was expecting to get upon death.
That's part of what makes all of this so difficult to work with, right? Is that the purpose of these estate planning documents is sort of, to lay out the intent of the testator. And then when those very documents are what's at the center of the dispute, then you sort of are having to go to all these tertiary sources to try to figure out intent, when it's like, because you're calling into doubt the veracity of the main document that should be telling you what intent is.
Like a lot of things in life, communication can solve or head off a lot of problems. If you communicate clearly with your expected heirs as to, what your plan is and why you're deciding to do what you want to do. And those are sometimes uncomfortable conversations because maybe you don't want to give, one of your children as much as the other children, but maybe there's a reason for it, right? Maybe you've been living with your daughter and she's been taking care of you and your son has been just visiting occasionally. And you feel that because your daughter spent more time with you and spent a lot of her money and taking care of you and living in her house, she's entitled to more of your estate than your son is. I mean, if you let them know that at the beginning, it's less of a surprise at the will reading, because that works great in movies when they read a will and people are shocked at what happened. It's terrible. It's terrible in real life.
The one about the Knives Out sort of corollary.
Right. I mean, if everyone hears the estate plan from the person that's devising it, it's harder to claim there was unfair influence in getting to that point because everyone heard it together.
Yeah, I think now that I've mentioned Knives Out, I think also it can be difficult because people are thinking of their entire lives with these people and not necessarily what's happened in the last, period of time where, perhaps an elderly person has left everything to, like as in Knives Out, a housekeeper or caretaker. And the family sees that as an interloper. But the truth of the matter is that, they've been coming around twice a year for the last 20 years, and that caretaker has been there every day and is potentially, maybe has undue influence, but maybe that's just their best friend now. Like, things have changed a lot since you were kids. Yeah.
A lot of these disputes aren't based upon money. They're based upon surprise, right? You didn't know that was going to happen. So you assume something must have gone wrong to cause your loved one to leave their assets or the bulk of their assets to you, a stranger, right? And you can't, how could that possibly be? They must have manipulated them and cajoled them and convinced them to leave their money to them through undue influence or some other nefarious means. And oftentimes that's not true. They just become closer with that person over time because they spend every day with them.
Mm-hmm. So, and this is a difficult question to answer, I realized before I ask it. But now that we're talking about sort of the emotional aspect of these things and the importance of communication, and I know that in your bio, we mentioned you have pretty extensive ADR experience. How often in your experience do these sorts of things actually require like a judicial sort of verdict versus eventually just everyone gets it out of their system and they can sort of fight their way to a settlement?
Well, I mean, most cases don't go to trial, I would say. I mean, I rarely go to trial. Most cases settle either through really good motion practice, summary judgment motions where you've really laid the case out and shows the other side has no case. Or the best way is to get to a mediation because these are expensive cases. These are hard cases to prove unless you've got some real smoking guns. So the best result is usually to get everyone together and then have a really effective mediator explain to everyone what the situation is. Oftentimes a retired judge is good for these types of cases because it explains to people how a judge would view these facts and can tell you the strengths and weaknesses of your case and make you realize that if you make a deal today, you can control the outcome. If you go to court, you have the illusion of control, but a judge is going to ultimately decide that. And sometimes they get it right and sometimes they get it wrong. Usually, no matter which way it goes, someone's going to take an appeal because they're on the wrong end of it. So it's going to take longer and cost more financially and emotionally. I mean, because these are disputes with family members. And even if you don't get along with your family members, it's still emotional to be doing battle with them and dredging up a lot of history that's better left unsurfaced. But all that stuff comes out in these types of cases because everything that's been percolating and building up for years finally spills over into these cases, and you get all of the dirty laundry waving all around. I mean, you talked about with Mr. Amos's case, his publicist said he wanted to delay the announcement of his death because he didn't want a circus. Well, the circus he didn't want is here.
Mm-hmm. And maybe instead of worrying about the announcement of his death, if he maybe sat his kids down and told them both at the same time what was going on, maybe it wouldn't have made a difference. I think that's important to say. The communication is the best way to try to avoid these things, but there's no guarantee. Even the best estate plans, sometimes the fight it's just going to happen, and you're just trying to sort of mitigate how bad it is.
I like to tell people I only get involved when the estate plans all go wrong. But a good estate plan will protect your assets. A great one will protect the relationships.
I think that's actually a really perfect note to end on. So we're running out of time. I'd like to thank our guest, Michael Napoleone, for coming on and helping us unpack some pretty complex topics. Litigation, not usually something we touch on too much on this show, but I think in this area, it's especially relevant and interesting. So thanks so much for coming on, Michael.
Thanks, David. I enjoyed our time.
And to all listeners, I'll see you, or I guess you'll hear me, on the next episode of Celebrity Estates, Wills of the Rich and Famous. Every estate tells a story. Some define a legacy, while others highlight lessons learned the hard way. To avoid costly planning pitfalls, trust companies, banks, and wealth management firms rely on the full suite of modern solutions from SS&C Black Diamond Trust Services. Whether optimizing for tax efficiency, managing complex assets, or securing intergenerational wealth, Black Diamond helps you bring clarity and control to the most complicated estates. Learn more at www.sscblackdiamond.com. SS&C Black Diamond, powering the future of trust and estate management.
Thank you for listening to the Celebrity Estates Wills of the Rich and Famous podcast. Click the subscribe button below to become notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of InformaWealthManagement.com. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.